The fifth one in this series on refugee is reading the refugees who were given citizenship. Why the Indian government under the Citizenship Amendment Act 2019. So the act which came in 2019 after the enactment of the Citizenship Amendment Act by the Indian Parliament in 2020, almost 12,000 Afghanistan refugees of Hindus and Sikhs, those who were the minority religious community, they fled to India due to the Taliban regime and their persecution on religious belief or on grounds of religion, and they were given citizenship by the government of India. And as regarding the very provision of the Citizenship Amendment Act 2019, almost it provided that those refugees of religious minorities, they came from Afghanistan or Pakistan or Bangladesh, and such religious minorities of either Hindus or Sikhs or Buddhists or Jains or Parsis, and also the Christians, those who are religious minorities in those above countries like Afghanistan, Pakistan, and Bangladesh. If they came over to India before December 2014, then they would be given citizenship as per the provisions of Citizenship Amendment Act 2019. So, on that ground, those religious minorities of Afghanistan, around 12,000 Hindu and Sikh minorities, as on the ground of religion prosecution or religious prosecution in Afghanistan by the Taliban regime, they fled to India, and those refugees of 12,000 in number were given citizenship by the Indian government as per the provisions of Citizenship Amendment Act 2019. And as the very act is applicable to only those religious minorities such as the Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, those who fled either from Afghanistan or Pakistan or Bangladesh, where they were considered as religious minorities and were prosecuted by the majority or by the governments in Afghanistan or Pakistan or Bangladesh. And if they settle in India as refugees since December 2014, they would be given citizenship of India in the very process of naturalization. And in 2024, the Indian government implemented the very provisions of the Citizenship Amendment Act 2019, and under the Act, most of the refugees, those who came over to India due to religious persecution or religious belief from Afghanistan, Pakistan, and Bangladesh are given citizenship under the provisions of Citizenship Amendment Act 2019. And this very act denied citizenship to the Muslim refugees who came over to India as because they came from the Muslim majority countries like Afghanistan, Pakistan, or Bangladesh, where they are in majority and the major religious communities, so they were not prosecuted by the majority government in Afghanistan or Pakistan or Bangladesh. So they are denied citizenship under the Citizenship Amendment Act 2019. The very provisions of the Act is only applicable to those religious minorities such as the Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians who are considered as the religious minorities in Afghanistan and in Pakistan and in Bangladesh. So, such categories of refugees, those who fled to India on the ground of religious persecution by the majority community in those states of Afghanistan, Pakistan, and Bangladesh, are eligible to be naturalized citizens of India as per the provisions of Citizenship Amendment of Act of 2019, which was enacted by Indian Parliament and which came into effect and implemented in the true sense of those provisions in the year 2024. But initially, when the act was enacted in 2019, in the subsequent year in 2020, the Indian government allotted citizenship to almost 12,000 Afghan refugees of the minority religious communities consisting Hindus, Sikhs, and Buddhists who were religiously prosecuted by the majority community in those countries, Afghanistan, Pakistan, and Bangladesh. So, in our lecture on this series number 5, we briefly discuss about the provisions of Citizenship Amendment Act 2019, which is exclusively applicable to those religious minorities who came over as refugees in India from the countries of Afghanistan, Pakistan, and Bangladesh, and in particularly to those minority religious communities in those states, such as the Hindus, Sikhs, Buddhists, Jain, Parsis, Christians. So, in this lecture, also in our previous lecture regarding refugee problem and crisis in India, in our fourth lecture on this series, also we have discussed in very brief about the influx of refugees and their settlement and the necessary provisions relating to their settlement, rehabilitation, and in regards to their employment, education, health, and other benefits that provided by the Union of India and some other provincial states in Indian Union and also the United Nations High Commissioner of Refugees that we have discussed in brief because there are lot of issues involving in regards to the refugees and their influx in India. In case of the Jews refugees, almost number of Jews after the formation of the state of Israel in 1948, they moved to the newly formed state in Israel. And as regards to the Persian refugees, many of the refugees they returned to Iran, or many of them accepted religious conversion to Islam. And also regarding the Tibetan refugees, most of the Tibetan refugees in India, in search of good avenues or better avenues and employment opportunities, they also, most of the numbers of Tibetan refugees, they, in search of better opportunities, avenues, they fled to the Western countries, even to United States of America, England, and to some European countries. And at present also, we found that India is facing the major refugee problem only in the form of the Bangladeshi refugees and the Rohingya refugees of Myanmar. And almost the Sri Lanka Tamil refugees, some of them also returned to their homeland Sri Lanka. Only a few numbers are left into the provincial states of Tamil Nadu, Odisha, and also in some pockets of Karnataka. And the major problem that is still continuing in India's refugee crisis is that of the Bangladeshi refugee crisis, and another major important problem for India is regarding the Rohingya refugees, those who fled from Myanmar due to the dictatorship of the army and due to the civil war in Myanmar. And in this context, I would like to discuss the very role of India's apex court, the Supreme Court, which in its judgment validly held the application and justiciability of the provisions of Universal Declaration of Human Rights of 1948, the provisions underlined under Article 14 of that Universal Declaration and also the provisions of Article 13 in the International Covenant on Civil and Political Rights, which was raised in the year 1966. In spite India is not a signatory to the Convention of 1951, which is relating to determination of the status of refugees also. India is not a party to the Protocol of 1967. So, hereby, in brief, we discuss in our previous lecture, also in this lecture, in regards to the refugee crisis and India, and also the Citizenship Amendment Act 2009 in its applicability and the scope of the act and how it is being implemented and to what extent and to whom in 2024, that also we have discussed. So hereby we conclude our fifth lecture on refugee crisis.